Be ready for the dictation. 3, 2, 1, start. In the present case, respondent number 1 has not instituted any suit for specific performance stop. Moreover, the power of attorney relied upon was unregistered and had already been revoked prior to the execution of the sale deeds stop. Therefore, respondent number 1 cannot rely on the unregistered documents to assert any proprietary rights and had no valid authority to execute the impugned sale deeds stop. Additionally, Section 54 of the Transfer of Property Act 1882 categorically provides that a contract for the sale of immovable property does not by itself create any interest in or charge on such property. Stop. In the present case, the appellant has contended that the agreement to sell was in substance a transaction executed as security for the loan amount received from respondent number 1 and was effectively in the nature of a mortgage, and they are now ready and willing to repay the loan amount and redeem the mortgaged property. Stop. As already stated, the agreement to sell, power of attorney, and other connected documents relied upon by respondent number 1 were unregistered and therefore in law cannot confer any title, interest, or ownership rights in respect of the subject property. Stop. It is also significant to note that these documents were expressly revoked by the appellant prior to the execution of the impugned sale deeds stop. Moreover, respondent number 1 has not filed any suit for specific performance of the alleged agreement to sell, which further renders his claim untenable. Stop. In the absence of a suit for specific performance, the agreement to sell cannot be relied upon to claim ownership or to assert any transferable interest in the property. Stop. It was further clarified that such documents are insufficient to complete a sale unless duly registered and followed by appropriate conveyance. Stop. The relevant paragraphs of the said judgment are extracted below. Stop. A power of attorney is not an instrument of transfer in regard to any right, title, or interest in an immovable property. Stop. The power of attorney is creation of an agency whereby the grantor authorizes the grantee to do the acts specified therein on behalf of grantor, which, when executed, will be binding on the grantor as if done by him. Stop. It is revocable or terminable at any time unless it is made irrevocable in a manner known to law. Stop. Even an irrevocable attorney does not have the effect of transferring title to the grantee. Stop. A grant of power of attorney is essentially governed by Chapter 10 of the Contract Act. Stop.